Hi, everybody. I'm Pamela D Wilson, and we are back for the next step in how to get guardianship of a parent. In this webinar, we're going to talk about how to petition for guardianship, and we're going to get into all of the nitty-gritty details and forms that you will need to prepare. The most important part of this webinar is to understand that there are a lot of details. You don't want to miss any of these. You want to make sure that you follow all of the directions from your state to complete the petition and set the hearing, because if you do not, for any reason, that hearing can be delayed or your petition can be delayed. So let's get started. So each state has their own process to petition for guardian. We'll talk about where you find the information for your particular state. You can go to the internet, in Google, whatever search provider you use, and search for state probate court forms. More than likely, it will take you to a website that will take you to all of the forms that you need. And I'll go through the forms that we use here in Colorado so that you can see the similarities between the forms that you may have for your state. We've already talked a lot about representing yourself as a pro se party. That means that you are representing yourself without an attorney. You're, in a sense, being your own attorney. And so let's take a walk through these probate forms. So pro se means you're representing yourself. Again, we talked about the fact that this is uncontested. You can do it yourself if it's not going to face a lot of disagreement from your family. And again, if it is, plan for a strategy. Hire an attorney, plan for the expenses, because there are filing expenses that we're going to discuss. So find the forms for your state. If you can find them on the website, more than likely there should be a phone number for the probate court. If you go to your county courthouse in the county where your parent lives, that's where you want to file. If you go there, more than likely they have a probate window. Staff at the probate window can talk to you about forms. They can give you examples of forms if you don't have internet access. And more than likely, they have a course that you can take that shows you how to prepare these forms. Additionally, they have courses on how to be a guardian. It's likely that your state will require you to take this course and to certify that you have taken this course before you petition for guardian. So you have a little bit of lead time here because it takes time for you to prepare these forms. Then you have to take the guardianship course for your state. And then there's a lead time to have a hearing. It's different by state. It could be 14 days, could be 21 days, it could be 28 days. You have to get on the court docket to schedule this. So guardianship is not something that, unless it's an emergency, that you really do overnight. It takes a little bit of time. The people at the probate window at your county courthouse can't give you legal advice. Again, I mentioned that you could hire a professional fiduciary, somebody like me, to help you complete these forms if you're uncomfortable, but I would give it a try yourself. As you'll see as we go through this, it's not that difficult. The most difficult part is the substantiation about incapacity, which we talked about in a previous webinar. So creating the court forms, the first thing that you want to find on your state probate website is instructions for completing a guardianship petition. Those instructions normally will list all of the forms that you need to complete. It'll tell you what the filing fees are. It'll tell you what the requirements are for the guardian and explain the whole process. And you may see this for the first time and you may think, oh my gosh, I can't do this. Yes, you can. Take it a day at a time. Complete a couple of forms each day. You can get through this. In Colorado, our form is called the JDF 840. I will include copies of every form from Colorado that are listed here in these slides in this course so that you can see what they look like. So you can see how they compare to the forms in your state and so that you can see the forms that we use. So as I mentioned in the prior webinar, you have to give notice to everybody who's involved, all of those interested people. Your parents spouse, their parents if they're living, brothers and sisters, your brothers and sisters, doctors, everybody. And the process is that you do this, you have to set a court hearing so that everybody can show up. Some states are still under what we call virtual court hearings because of COVID or other reasons. You may end up having a virtual hearing instead of an in-person hearing. It just depends on what's going on in your state at the time that you file. As a guardian, if you are the person who is proposed, you have to file your background information. And there's also a form for that we'll talk about. So let's get into all of these forms. So as you see, there's a lot of numbers going down on these slides. They're all JDF forms. And the first one is just a probate case information sheet, which is really about the case. It's a guardianship case. Who is the respondent? Who's the petitioner? Who's the proposed guardian? That just gives the court the idea of information about the case so that a hearing can be set. Now, if you have interested parties that you don't have phone numbers for or mailing addresses for, you have to take an additional step. You actually have to publicize the court hearing in the newspaper for a period of 3 or 4 weeks. Again, it depends on your state. So there's extra forms that you have to fill out to do that, and those are listed here. Then for the guardian, there's usually an acknowledge of responsibilities and an acceptance of office. That acknowledge of responsibilities usually has a provision in there that you've taken a guardianship course either on the state website or through the probate court or somewhere else, and that you fully understand what it is you're supposed to do, because after this court hearing, you have reports to file. You have to follow through. There's an annual report that has to be filed. You have to send people copies of your appointment. There are a lot of things involved in this court process that are very important to do. And then you have what's called a guardian letter and a guardian order. Those are the documents that actually grant the guardianship that you provide to medical providers and people in your family so that they know that you are the guardian, so that they know that you have decision-making ability. Again, very important, be so thorough with all of these documents, know what the deadlines are. If you have questions, ask your probate court. They can answer questions about forms and deadlines to make sure that you are doing everything appropriately. And if you can, I highly suggest taking a class that shows you how to do all of this. You will feel more comfortable and you'll be more confident that this process will be easier. So you have to provide a notice of the hearing. So when you have all of these documents completed, you take them to the courthouse and they collect information from you and they set a court date. You have to tell everybody involved when that court date is so that they can actually show up. A document goes to your parent to tell them about the court hearing. A document goes out to everyone else. And then you have that petition that they actually receive copies of. So this is an example of a header of the guardianship form. So if you look at this form here, it's, are you petitioning in a district court in a county or in the Denver probate case here in Colorado? You list the county that you're petitioning in. Colorado here, it could be Jefferson, Arapahoe, Broomfield, Clear Creek, Gilpin, Arapahoe. In the interest of the respondent is your parent. And you see the section where it says attorney or party without attorney. That is whoever is filing the petition. Doesn't have to be the guardian. Someone who is not the guardian, who is just interested in the welfare of your parent, can file this petition. The court, the box where it says for court use, they will usually stamp that with a case number, division, courtroom, give you additional information. So this header is usually the header on every single page that you will complete for the guardianship hearing. So once you have this set, it's the same for every page. It's the top of every single page. Next up is just basic information. So it's basic information about the court, the case number, the state, the date of the proceeding, and what the proceeding is about. And it says a statement about who's petitioning. So is it just a person who's interested in the respondent? Is it the respondent? So again, as I talked before, your parent, who may realize that he or she has dementia, can petition for themselves to appoint someone. And then, is it permanent guardian? Is it an emergency guardian? So that tells the time sensitivity of the need for the court hearing. The next form is talking about venue and legal documents. So normally petitions are filed in the county where your parent lives, and that's the venue. So it says venue for this proceeding is proper because the respondent resides in this county, or there is a couple other check boxes. And it talks about, has the appointment of a guardian previously been made? This would be in respect to a successor guardian. So the present guardian who says, I can't serve anymore, I want to appoint a successor because my parent didn't appoint a successor in the medical durable power of attorney document. Or when the prior petition was done, a successor guardian was not listed. So we have to go through this whole court process all again. Then Colorado now requires the inclusion of the power of attorney documents. Some states may or may not have this provision, but again, this is done because the person who is that agent under medical durable power of attorney has some priority for this appointment. So the court wants to know if that exists. Also, there's mention of here, you see a beneficiary deed or a will. So this is the provision that I mentioned before, where if there's a married couple and one spouse is the caregiver and one spouse needs care because of dementia or Alzheimer's, the healthy spouse gets sick. They know that they're going to pass away. They put a provision in their will that says, when I pass away, I give priority to this person to be agent under medical power of attorney for my surviving spouse, or I want this person appointed as guardian for my spouse. So that again is the advanced care planning for guardianship and incapacity. Next up is, why do we even need this petition? It goes back to identifying the statute of incapacity for the state where you live so that you understand the information that has to be provided. This statement here, and I'm going to read it from the slide, so I'm going to look away from you for a moment, but it said the respondent is unable to effectively receive or evaluate information or both, or make or communicate decisions in such a manner that the person lacks the ability to satisfy essential requirements for physical health, safety, or self-care, even with appropriate and reasonably available technological assistance. That is the statute for the state of Colorado. Then it talks about, why is guardianship necessary? You'll see that little checkbox there for physician letter is attached. I can say with almost certainty that if you do not attach that, and there is an objection at the hearing, the objection will be, we object to this guardianship until medical incapacity is evaluated and proven. So do the work up front, be complete. It's easier for this petition to be granted the first time. And then it talks about the powers, whether it's unlimited or restricted guardianship, or whether there are limitations. Next up, priority of appointment talks about who has priority. Is it a guardian appointing a successor guardian? Is it the person who's agent under medical power of attorney? Is it the person that your parent wants? Is it a spouse, a brother, a sister, another family member? Who has priority and why do they have priority? Compensation is an important discussion. You may or may not know that a guardian can be compensated for all of the time and effort that you put in, because as we talked, being a guardian can be time consuming and it's a lot of work. If you have hired an attorney to represent you at this hearing, your attorney is also entitled to compensation. The court wants to know how much everyone is going to be paid. If you're a family guardian, you may be wondering, how much can I be paid for this? How much can I bill? You'd want to do a little bit of research on what family guardians in your state get paid, but I can honestly say a range of maybe $20 to $30 an hour to $40 an hour if you're a family caregiver is comparable. But you have to document all of your time, what you're doing, what the results are. You have to actually eventually submit that to the court or to a conservator for approval. You can't just go into this thinking that you're going to make a lot of money being a guardian for an elderly parent, because if your parent needs care, the priority is their care. It's not necessarily paying you as that guardian. List of assets. The court wants to know, how much money does your parent have? Do they own property? What do they have in savings and bank accounts? Again, that is important, and it's important to document because you as that caregiver have to plan for care that will use these assets up to pay for their care, to pay for in-home caregivers and medications and healthcare premiums and hospital visits and all of that. Guardianship involves making a plan and working within a budget for your parent. Appointment and additional requests. So this could be additional requests. So in addition, I request that if my parent is going to be moved, that I will submit a petition to the court. If the home of my parent has to be sold, that again, a petition will be submitted to the court. If I want to hire anyone else from my family, that a petition will be submitted to the court for approval. Again, you're trying to avoid future court issues down the road over things that you may or may not know are going to happen. If you can do it up front, it will save you a lot of time, effort, frustration, anxiety later. All of these forms have to be verified and signed, especially the petition has to be certified by a notary. And a lot of the other forms just require signatures. Again, your state instructions can tell you which need to be certified and which need to just be signed and submitted. So at the hearing, obviously someone has to get your parent to this hearing. Normally, it could be the petitioner, it could be the guardian, or your parent's attorney may request to take them to the hearing themselves so that they have some time together. You want to arrive, I would say, at least 30 minutes before that hearing. You actually have to go into the courtroom and say that you are there so that the hearing can occur in the order of scheduling. So let's say your hearing is 2 o'clock on Thursday. You're probably not the only one. There's probably 10 other hearings scheduled for 2 o'clock on Thursday. The earlier you get there, the earlier that you are assigned to the first slot, the second slot, the third slot. Also, having that time before the hearing allows you to have a conversation with your parent's attorney, with your attorney if you have one, with family members, because you will have the opportunity to get on that stand and swear that you are giving honest information, the truth, nothing but the truth, to present evidence for guardianship for your parent. So you want to be prepared to give that testimony, know what you're going to say. You don't want to go into any long explanations. It's basically, the hearing is short, present the facts, state the information that you have, and move on. Assuming that the hearing goes positively and the judge grants the guardianship, you just don't leave the courthouse. You have to go back down to the probate window to get your guardian order and your letter, certified copies that you pay for, that have a seal on it that you submit to healthcare providers, doctors, anyone else who needs the information, health insurance companies. And there's also a process where you have to send out the notice to all of the interested parties again to say, yes, I was appointed. Then you have to start preparing for all of the other things that you have to do. So after the hearing, again, go to the probate window, make sure that you understand exactly what you have to do next, because you mail copies of these documents out. You normally have an initial guardian report due within 60 days. Again, it may differ by your state. And then you have an annual report due. That first report is very important because it talks about what are your goals for your parent over the next 12 months. Financially, how is the money going to be spent? Are they going to stay at home? Are they going to move to a care community? What exactly are you going to do? And then when you do the report 12 months from now, you go back and you say, this was what I intended to do. This is what I did. This is what changed. These are the unexpected things that happened. And this is my plan now for the next 12 months. Realize that any interested party can ask you questions. They have the right. Adult Protective Services can follow up with you, the ombudsman, the police. That is part of being a guardian and being full disclosure and full transparency. So in summary, going through this process can be very intimidating if you've never done this before. But if you follow all of these steps to the T, you want to dot your I's, cross your T's, make sure everything is completed as it should be, you can file as a pro se party and avoid a lot of legal fees. On the other hand, if it's going to be a contested hearing, you will have attorney fees. You will know what they are. The attorney fees can be paid by your parents' estate. If you hire an attorney, make sure you hire the right kind. Elder law, probate, estate planning, litigator, somebody who performs regularly at contested hearings. If you hire the wrong person, you may not have your appointment confirmed. You may lose. You don't want to go through all this effort, hire the wrong attorney, and then not have the petition granted. So up next, in the next webinar, we're going to talk more about the responsibilities of guardianship. Again, to confirm that you really want to be this guardian. You really want to do all this. We'll go through more personal stories of me and my clients, talk more about responsibilities and the realities of the time commitment and the life commitment that it is to be a guardian for an elderly parent. I'm Pamela D Wilson. As always, my website is PamelaDWilson.com. If you're looking for more courses, more support, support.PamelaDWilson.com is that website. I thank you so much for being here with me. I'll see you in the next webinar.